Welcome. Session on Contract Labour Act, Regulation and Abolition Act 1971. So this is a very good, very important piece of legislation for all the corporates who are engaging in contract labour in various activities. This has assumed a lot of importance nowadays. Let me take you through a little background of the act, why this act was made, came into being. During the early part of industrializations, establishments had difficulty in procuring manpower and deploying them. Requirement of supply of labor was a major problem because the reasons are many. One is that low status of the factory workers, lack of labor mobility, caste and religious taboos, then language were some of the problems which most of the employers in general, and particularly British employers or their representatives were not familiar. Therefore, naturally, they had to depend on a middleman who helped them in procuring, recruiting people and procuring them and the control of labor. These middlemen or the contractors were known by different names in various parts of the country. Then contract labor were almost considered as exploited section of the working class, mainly due to lack of organization on their part, because this is one of the most unorganized sectors and lot of problems they used to face, and they became an exploited section. Due to this, in 1860 itself, Whiteley Commission recommended the abolition of contract labor by implication. You can just see, as back as 1860, the contract laborers were considered as exploited section of the working class due to lack of organization on their part. You may be surprised, even in, there was a legislation at that time, even earlier to 1860 itself, an enactment called Workmen's Breach of Contract Act 1859, it was in prevalent when Britishers were there. Then it was holding them criminally responsible in the event of breach of contract of service. Can you imagine this kind of an extreme step of, in case of breach of contract of service, they will be held criminally responsible. So this is the state of affairs of the contract laborers at the time. Due to this, as early as 1960, Whiteley Commission was formed, and they recommended abolition of contract labor by implication. And subsequent to this, the government also constituted various committees to go into details of the engagement of contract labor. One such committee was in 1838, that is called Bombay Textile Labor Enquiry Committee, stated that if the management of the mills did not assume the responsibility for such labor, then there was every likelihood of this being sweated and exploited by the contractor. So it gave a very strong recommendation, and it gave a recommendation saying that the contract labor system must be abolished. Then in 1941, one more commission called Bihar Labor Inquiry Committee also condemned the practice of recruiting labor through contractors, because they said the contractors ordinarily lack a sense of moral obligation towards labor, which the employers or managers are expected to have, and therefore do not often hesitate to exploit the helpless position of labor in their charge. So the very strong message was given by this committee, and they also condemned this, and they said this must be prohibited. As a result of all these developments, then the government, what they did was that in the scope of definition of workers under Factories Act, under Mines Act and the Plantation Labour Act were enlarged to include the contract labour also, to see that at least the benefits, the privileges, what they get under Factories Act, Mines Act and Plantation Act, this contract labour also get this kind of a thing. Another milestone in this area is in 1960, the Supreme Court in Standard Vacuum Refinery Company vs. Workmen, they came with a very harsh points on the engagement of contract labor as back as 1960. They said the work is perennial and must go on from every day, go on from day to day. The work is incidental and necessary for the work of the factory. The work is sufficient to employ considerable number of whole-time workmen. The work is being done in most concerns through regular workmen. He said that contract labor should not be employed here. So this kind of a message what they gave by Supreme Court as back as 1960 itself. Then subsequently in the second 5-year plan, the Planning Commission also stressed the need of improvement in the working conditions of contract labor and thus recommended a special treatment to be given to contract labor to ensure continuous employment where it was not possible to abolish such type of labor. So this scenario as far as the government is concerned, and in spite of all this, government also was a party to add to these issues, engaging large number of contract labor workers. For instance, in railways, then shipping and transport, public works departments, telephone and telegraphy, electricity boards, power distribution, textile, jute, foundry, steel plant, etc. Even the government started engaging contract labor in huge numbers. Ultimately, what happened on account of the lack of legal obligations to control their living conditions and working conditions, lot of exploitation were taking place. Low wages, poor working conditions, lack of health and safety hazards, no social security covers and no restrictions on working hours. These are the exploitation took place. Hence, under the circumstances, the Government of India came out with the legislation, Contract Labor Regulation and Abolition Act in 1971. The object of the act is very clear, to regulate the employment of contract labor in certain areas, to provide abolition in certain circumstances and matters connected therewith. The object of the act is very clear. If you see the title of the act itself, you will know regulation and abolition. The intention and the object is to regulate the conditions of workmen, and where it's possible and where it's not possible, then go for abolition. So these are the two steps. Hence, now what we will do for our discussion purposes, we will discuss the regulatory portion of it first, and then we go for the abolition side of it. Here is the information, the definition of workman. Here the definition of workman is exactly similar to that of what is defined in the Industrial Disputes Act. It means that any worker who is engaged in skilled, semi-skilled and other areas for wages with express or implied conditions, but it does not include the people who are engaged in managerial and supervisory position, and also an out worker. Who is an out worker, he is also not covered. But I will explain the concept of who is an out worker. So for the purpose of understanding the definition, now it's purely the persons who are engaged in other than managerial and supervisory position, all are workers. In simple terms, we can say this. Now here, who are not workmen under the Act as same thing, the persons employed in managerial and supervisory capacity, and persons employed mainly on supervisory capacity, and an out worker. Who is an out worker has been defined. That is to say, a person whom in any articles or meters are given out by or made principal employer to make up, clean, etc., outside the business, outside his premises, and not under his control, he is an out worker. To give the example, I can say this. For instance, now in the area of beedi manufacturing, or in case of agarbatti manufacturing, this concept is very much prevalent, in the sense that the materials are given to prepare outside, and they do the job outside and come back. They are classified as out workers because they don't work under the supervision of the principal employer in the premises. They do outside on their own. Similarly, cleaning operations. Any part of the machinery or anything to be cleaned outside, it can be done outside with not under the supervision of principal employer, then they are out workers, they are not covered under this regulations. But if the work is carried out under the control and supervision of principal employer, then they don't get this benefit. So this is very important. Important thing is that the control and supervision of the principal employer, not on this, they are called out workers. Now here, important thing we should always note that here is that under section 2B, this is very extremely important to note, a workman shall be deemed to be employed as a contract labor in or in connection with the work of an establishment when he is held in or in connection with such work by through contractor with or without knowledge of principal employer. So this is very important. Even if a contractor engages a person without the knowledge of principal employer in the premises, he is deemed to be contract labor and you are obliged to follow all the regulations applicable to him also. So this is an extremely important case. The next definition is the definition of contractor himself. It has been defined that in relation to establishment, he is a person who undertakes to produce a given result to the establishment other than mere supply of goods or articles of manufacture of such establishment through contract labor, or who supplies contract labor for any work of the establishment and includes a subcontractor. This you have to note it very, very carefully. So it means that a contractor includes a subcontractor. Normally what happens is that when we engage a contractor, when we give contract to him, many times the contractor further outsource to his own subcontractors and they start coming inside the factory and work. In such cases, the subcontractors who are working in the premises of the principal employer are also deemed to be the contractor under this act, and then they need to follow the regulations and the other obligations under the act. So this is an extremely important thing, one has to note that. So in case of Salar Hydro project versus state of Jammu and Kashmir 1883 itself, they have held very clearly piece-rate workers are subcontractors appointed by the main contractor for execution of work are contractors within the meaning, and they must also obtain license under section 12, and they are to provided facilities to the workmen as contemplated under the Provisions Act. So this is extremely important, one we should know this. Of course, the definition of principal employer is very case. In case of factory, the owner or the occupier or the manager. In case of a mine, the agent. In case of any other establishment, a person responsible for supervision and control of the establishment is the principal. But here we must note that the principal employer is a person by name. You cannot say the organization name as principal employer. You have to name by a person. That's extremely important. Of course, the definition of wages, it has got the same meaning as given in the Payment of Wages Act. Of course, if you see the definition of wages in the Payment of Wages Act, it is an inclusive one. It means that the definition of wages in the Payment of Wages Act, it includes all salaries, allowances payable in respect of work performed by a worker is completely included in the definition of wages. Of course, the certain things are excluded, like for instance bonus and contribution to PF and ESI and travelling or conveyance expenses, and to allowances given to some defray certain expenses and gratuity payable are out of the definition of wages. Now here the Act has got a very, very wide coverage. It includes all factories, establishments, government offices and departments, local authorities and mines. It is a very wide application. So here the applicable Act is that any establishment engaging 20 or more workmen employed through contractors during preceding 12 months as contract labor, this Act automatically applies. Every contractor who employs 20 or more on any day during preceding 12 months as workman, the Act applies to him. So it means of both principal employer and the principal employer and the contractor, the number is 20 or more during the preceding 12 months. The act is not applicable in case of intermittent or casual nature is performed. Here also, act has defined what is an intermittent nature. If the work performed is less than 120 days during preceding 12 months, and in case of seasonal character, less than 60 days in a year, it is called intermittent, and the act is not applicable in such cases. So this is the important thing to be noted. But when the established principal employee, when he wants to count 20 number, he has to take into account all the contract workmen engaged by him through different contractors, and all the numbers should be taken into account while calculating 20. This is very important. Take for instance, one establishment has got four contractors. One employs 10, another employs 15, another employs 2, another employs 3. Then what happens? We have to take all into total and to see whether it crosses 20 or not. Then the applicability act comes in the picture. Here the establishment is, of course, in case definition is very wide, I told you already. Then here, in case of Madras High Court also has held that even Christian Medical College falls under the definition of establishment, and the contract labor becomes applicable. Now, safety is most important for a contract labor. Definitely, obviously, works in establishment, very important. Now, if you see the definition of worker under Factories Act, he is also a contract worker, is also a worker under the provisions of the Factories Act. Hence, what happens? He is also liable, and the principal employer is liable to take care of all the safety and health hazards, etc., of the contract labor engaged in the premises. The occupier shall be responsible in case of any employment injury to such workers. So this we have to note it, very important. So a contract worker is also deemed as worker under the Factories Act. Now, it has got advisory boards. It deals with advisory board because the central government or state government has to be properly advised depending on the needs of the requirements of society and the working class. For this purpose, it envisages formation of central advisory board at the central government level and state advisory board at the state level. The board consists of Chief Labour Commissioner or State Labour Commissioner ex officio, and it has representatives from employers and trade unions. The job of the advisory board is very clear. They have to oversee how the act is being implemented and what are the concerns. Are there any requests from any corner for any consideration or any changes to be made? The advisory board has to make a study of the entire thing and also recommend to the government about the recommendation. Of course, when I come to section 10 of the prohibition of the system, their role is much more, I will deal it separately. Now, coming to regulatory measures, under section 7 is the registration of the principal employer. So here, if the establishment falls under the coverage, it means that if they are doing more than 20 or more contract labor, they have to go for registration immediately. Then, what is the effect of non-registration, non-revocation of the registrations? Here, the Act very clearly says no employment of contract labor. So, if you don't take registration, you are not permitted to employ contract labor. That is one. Secondly, it is also an offence under section 23 and 24 of this Act, which I will deal with separately. Then registration obtained by the registration can be revoked by the registration authority after giving opportunity for the principal employer, and previous appropriate government can revoke the registration if the registration has been taken by misrepresentation or suppression of some material facts, or the registration has become useless or ineffective. In such circumstances, the certificate of registration can be revoked. This is very important. See, important thing is that in a situation where either of these conditions are not satisfied, a person will be employed by immediately by the principal employer. See, this is one very damaging case. It cropped up in 1992. Food Corporation India Workers Union versus Food Corporation of India. Here, the certificate of register is required to obtain by principal employer in Section 7. The license by the contractor and association, they have to take it. The workman can be employed as contract labor only through licensed contractors. Hence, unless these conditions are complied with, the provisions of the Act will not be attracted. But in a situation where either of these conditions is not satisfied, then position would be that workman employed by intermediary is deemed to have been by the principal employer. So these are very, very damaging. It means that there is no registration taken, there is no license taken, but the contractors are being engaged to supply contract labor and they don't have any status or recognition either under Section 7 or Section 12. Then what happened? The court come to the conclusion that those workers shall be employed by, deemed to have been employed by the principal employer. This is another extreme view taken by the Food Corporation of India by Gujarat High Court. Hence, it is absolutely necessary that the registration and licensing are must. Now here Section 12 deals with the licensing of contractors. Here also no contractor shall engage in a contract labor if he employ more than 20 without obtaining a license. This is very important. Here also the license can be revoked, suspended or amended by the licensing officer in case he is satisfied that license has been obtained by misrepresentation fact or suppression of material fact, etc. and failed to comply with provisions of the Act. The licensing officer can always revoke the license. Now, what is the effect of non-obtaining license by a contractor? Here, there is a prohibition on the contractor himself that contractor shall not undertake or execute any work through a contract labor. So, there is a prohibition on himself. He cannot do that. And here it is an offence under Section 23 or even 24. So, this is the prohibition. Now, here for instance, so if you summarize the whole thing, if there is no registration and no license in the establishment to which the Act this applies, the consequences are that no engagement of contract labor and is an offence under Section 23 and 24 of the Act. Now here, the question is, what are the consequences of no registration of the license notwithstanding provisions of the Act? This question came up before various judicial pronouncements in this question. All the judgments have been trend setting and there are two phases of these judgments. Now again, this is very, very interesting to note all these things. In case of Best Government Workers Union, in 1985, the contract labor should be utilized for the nature of work in respect of which the license has been obtained. That's very important. Supposing the contractor takes the license for housekeeping, he must engage them only on housekeeping. He cannot take the license for housekeeping and engage them on production activities. So therefore, the management of utility service of nature of not permitted, they would cease to be the contract workmen. So the very, very extreme decision given by Madras High Court in the year 1985. So see the consequences, how it happens. So here, we must ensure that we must engage the contract labor only in such areas where the license has been taken by him. Otherwise, it becomes a complicated question of law and the serious consequences will follow. So in a way, both conditions are not satisfied, the position would be that employee by intermediary deemed to have been employed by principal employer. Food Corporation was just 2 minutes back, I had told you on this case, Gujarat High Court, same thing will follow. Then United Labour Union versus Union from 19 Bombay High Court has said that the Act, there is no provision that the service of contract labor principal employer stand terminated on the contract labor become invalid or abolished. This is another very, very dangerous judgment. What it says is that supposing we have engaged the contract labor and without without taking these positions, and if you want to terminate them, there is no, the Contract Labor Act doesn't say that you have to terminate them. What does it mean? It means that you have to take them back. You have to keep them. That's the, in other words, that becomes an implied meaning. So this is a very, very dangerous judgment. In the case of, this is another dangerous judgment by Supreme Court in the year 1999 in the case of Haryana Electricity Board case. Here they say that if there is no registration and no license, the contract worker are to be deemed to be the employees of the principal employer. So this is again the extreme judgment by the Supreme Court at this time. So when the Supreme Court laid down this principle in 1999, now all other high courts also started saying repeating the same judgment, and this provided a very prominent platform for the trade unions to litigate upon. Hence, there is a big issue and chaos on account of all these things. Let us see the subsequently what happens. I will give you the latest picture of it. Then the regulatory measures. The chapter 5 also says welfare and health of contract workers. Provision of canteen if there are more than 100. Then provision of restrooms, and in case of overstay by night, the contractor has to provide. Contractor has to provide sufficient supply of drinking water and sufficient number of latrines, etc. Then contractor has to provide the medical facilities, health facilities. Here, in case the contractor fails to do all these things, then the responsibility shifts on to the principal employer, and he shall provide the same thing, but of course he can deduct the expenses incurred through his bill, whatever is payable to him. Then section 21 fixes the responsibility payment of wages. The contractor shall be responsible for payment of wages to each worker. He is his responsibility. Now here the principal employer is also not excluded from this. He is also involved. It is the responsibility of the principal employer to nominate his representative to be present at the time of disbursement of wages or salary to the contract labor, and he must make an endorsement in the wages certifying that the payment has been made in his presence. So this obligation has been put both on the contractor and as well as on the principal employer. So this is extremely important. And in case the wages is not paid by the contractor on time, or the contractor pays less than the prescribed minimum wages, then it's the responsibility of the principal employer to make good and pay, but he can of course recover from the contractor's bill. But ultimately, the contract worker should not be deprived of these facilities, whatever he is entitled for. Of course, for this, to support this, Hindustan Steel Work Construction was Commission of Labour in 1987 has clearly said principal employer should pay the contract labour the difference in wages. Then Kerala High Court, Karnataka High Court in TK Valley's Regional Labour Commission has held that if the contractor fails to pay wages, the principal employer is liable to pay and preempts the contractor. Then if the contract not paid, the principal employer has liable to pay and recover. Indian Airlines versus Central Government, New Delhi, in the case of held by Delhi High Court. There are a few cases. Now the contract workman also, the contractor also, all the legislation applicable to the principal employer is also applicable to the contractor and contract labor. To give an example, for instance, employees stating ESI or the Provident Fund, maternity benefit, if ESI is not applicable. Then Employee Compensation Act, if ESI is not applicable. Then National Festival Holidays Act, Labour Welfare Fund Act, then Payment of Minimum Wages, Payment of Wages Act, then Payment of Bonus Act and Payment of Gratuity Act. All these acts are applicable to the contract workman and of course the contractor. Now here the obligations of the principal employer is much more. He has to ensure that the contractor follows and complies with all these legislations in toto, otherwise the responsibility automatically gets shifted on the principal employer. Hence the principal employer had to take care of all these things. Now I talked to you about the penal provisions, section 22 and 23. Here 22, 23, 24 section clearly says that they are liable for punishable with an imprisonment up to 3 months or even fine up to 1,000 rupees or both in case of violation of section 23 and 24. Now this is about the regulatory measures. Now you can see at least the regulatory measures are being specified, directed and informed to follow, and if you don't follow, what are the consequences have been told very, very clearly. Now the second portion is about, we talk about the abolition. What are the processes to be followed in case of abolition? Section 10 of the Act says the prohibition of contract labor. Here the process is this: the State Advisory Board or the central advisory board or to be consulted by the state government before the contract labor abolition takes place in a particular domain of work or particular institution. So the matter has to be, the state government or central government has to take and seek advice from them. So normally the thing is that the advisory board, whether it's state or central, reviews the particular case, whether it is a case for abolition, to recommend abolition as per section 10 of the Act. Here, what are the factors they consider normally? The factors they have to consider is that what is the condition of work and benefits provided to the contract labor in an establishment or in a particular domain of work. Whether the process or operation of work incident necessary to business is critical or that is carried on. Whether it is of perennial nature, that is to say that sufficient duration having regard to the nature of industry, trade or business or manufacture or occupation that is carried on. Whether it is done ordinarily through a regular workman in that establishment. Whether it is sufficient to employ considerable number of full-time workmen, in this case it has to be seen. All these questions have to be answered, have to be investigated, and then only they can come to a conclusion whether the particular operation, particular segment of contract labor to be abolished, should they give a recommendation to the state government or central government. So this is extremely important. Another thing is, normally what we come across is that normally we talk about core activities and non-core activities. Normally we talk about it. But actually the Act doesn't say anything about core activity or non-core activity. The Act has not defined what is core activity and what is non-core activity. Normally, frequently we discuss this, whether it is a core activity, non-core activity, and a lot of debate takes place on this. But actually, there is no definition under the Act. But only if we can draw some references from section 10, where it says the process or operation is incidental or necessary, whether it is of perennial nature, whether it is done ordinarily through regular workmen or a sufficient employee to consider. There is some references we can draw from section 10, but actually there is not a clear-cut definition on this. Now here, for instance, now to start with, the functions like security, housekeeping, canteen, and estate maintenance, and other areas further extended to material handling, scrap removal and cleaning, packing and forwarding, etc. are all classified as non-core functions according to us, and we are engaging, the contract taker being engaged. But now it is further extended to various activities, even in the manufacturing process itself, where such activity doesn't add value to the product. Any process, let us take the example of a single process of where it has got 10 steps of manufacturing process, and if it is found that one or two steps do not carry value to the product, then what happens? That particular process is being taken out and then giving it to outsourcing job. Take for instance logistics in a factory. Logistics is required, but again it doesn't add value, so we move out of that. In between cleaning and then decleaning, etc. of the components, again it is being outsourced for various activities. Because the order of the day is that every entrepreneur has to be very highly cost effective. It means that he has to save as much as cost on the product as much as possible. Hence this activity is being expanded further and further now. Now we should not disappoint that the state government or both central government have got powers to prohibit the engagement of contract labor, whether it is core activity or even non-core activity, provided it falls under the parameters section 10 and the state advisory board or central advisory board accordingly submits a recommendation to the government. But in fact, if you see the last 10 years or even 15 years, if you see instances of prohibition of engagement of contract labor, mostly it is on so-called non-core activities what we are talking about. That's exactly. For instance, canteen is being abolished, and then in hospitals, engagement of housekeepers and security was abolished. in airport authority case, where the maintenance of the airport like housekeeping, cleaning, etc. was abolished. So these are some of the instances of where abolition has taken place, so-called non-core activities also. Now, the working apparent as industry common. The dominant idea of section 10 is to find out whether the contract labor is necessary. That's number one. The words other work in any establishment are also in section 10 are very important. The work in the establishment will be apparent from section 2, incidental necessary to the industry. So this is to be examined as per the Supreme Court guidelines in Government of India versus Union of India. Now here in the case of catering cleaners of Southern Railway versus Union of India in Supreme Court, they said that there appears to be clear that the work of cleaning and catering establishment and pantry services is necessary and incidental to the industry or business of railways. Hence the work is perennial nature of work. The work is done through regular workmen in most of the railways. The work requires employment of sufficient number, hence the matter taken for prohibition. This is how even the Supreme Court commented on this case. In the case of Shankar Mukherjee versus Union of India, again Supreme Court has stressed this point that there is no denial or amendment or material on record to show that the job of loading and unloading bricks is not incidental or allied to the stacking of the bricks. There is no material basis to show that the job of loading and unloading is not perennial nature. So hence they said that is a case for prohibition. So here in fact in the case of Philip Workers Union versus State of Maharashtra, Bombay High Court has said that the act applies to establishing 20 or more workmen or employed as contract labor. It is the aggregate of the contract labor employed in the establishment, though for different purposes and to different operators. They have taken into determine whether applies or not. When it applies, the appropriate government has to prohibit the engagement. Then here, when the government notification is issued, a general notification under section 10 can be of the act abolishing can be done for a class of industries can be issued. In case of Hosur Tribute, State of Karnataka in 1999, it has been held. See, example is that abolishing engagement of contract labor in industrial canteens was one notification covering all the industries across across State of Karnataka. And a single notification also can be issued to any establishment. It is also, the thing is there. For instance, in the case of Bharat Frizza versus State of Karnataka and in Dalmia Cement versus Government of India, they have held that a single notification can be issued to individual falling in a particular category only. There is no required need for separate notification. It is also held that. Now here, on this prohibition, there are umpteen number of cases of prohibition of contract labor on many process operations and related areas. Now the question is, what happens to the contract labor so engaged in these areas and what leave are they entitled for? These are the two questions which came right from 1975 onwards to a particular stage. There has been spate of cases coming up and important judgment have been pronounced by many high courts including Supreme Court of India, and it's a matter of deep concern at that time. So few cases are compiled for the purpose of telling you how the Supreme Court also endorsed such kind of a view. They said in the LIC case, they said canteen workers engaged with the contractor in LIC office are to be absorbed by the LIC. Then Air India statutory case, Supreme Court in 1997 held that canteen workers engaged by contractor in industrial canteens are entitled for absorption. In R.K. Panda versus Steel Authority case, Supreme Court has held engagement of contractor and contract merely camouflage will be against the spirit of contract labor, and the workers working on different contractors for last 10 years will be absorbed by the principal employer. These are the kind of decisions the case came up. In the case of Gujarat State Electricity Board case, Supreme Court came, if the contract is sham, the contract workers are deemed to be the employees of the principal employer. Then in case of engagement of workers is prohibited by the government, the contract workers shall be automatically be absorbed. This is LIC case again in Supreme Court 1995. See, look at all these decisions. It's a very one-sided decision taken by Supreme Court at that time. Still more things are there. In case of Airport Authority, central government abolished the engagement of contract labor. In sweeping, cleaning, housekeeping of airports, the Supreme Court ruled that affected workers will have to be regularized. This is the Air India Statutory Corporation in 1997. Again, in the case of Pyramid Chandraraha versus LIC, again canteen workers, they have to be absorbed. Then in the case of Petrochemicals Corporation, workmen of statutory canteen would be the workmen of the establishment only for the purpose of factories act, not for all purposes, proved that the establishment excluded complete control over the employees of the canteen. And here in the case of in one of the case Supreme Court held that under section 46 there is obligation by the employer to run a factory canteen wherein 250 workers are ordinarily employed. Government corporation running the canteen in fact a statutory requirement under Factories Act. Hence canteen though run through contractor would be treated as employees of the corporation for all purposes. When the adjudicator holds contract as sham or conflict, the contract labor shall automatically be absorbed. The Steel Authority case. In the case of Airport Authority, central government abolished the system and the Supreme Court said that the workers shall be absorbed without any question. And even in the case of Harishankar Sharma with artificial limbs, again the same question of statutory canteen under Factories Act, they said that being a statutory canteen, the workers working in this canteen through contractors shall be deemed to be the employees of the principal employer. Then National Thermal Corporation, again same view taken by as far as the canteen engaged with contractor by NTPC and the statutory obligation under section 46 of the Factories Act, they said that the workers shall become the employees of NTPC. Again, in the case of Vishnudasanagam Venkaya versus others, again the same Supreme Court again they said, section 46, they said that canteen workers, regulation of services, principal employer has the statutory duties to provide canteen, hence they have to be absorbed. This is the kind of thing. So, all these cases of Supreme Court created a new platform, new right to the contract labor. The position became so overlapping and confusing, even engagement of contract labor started giving rise to a complicated question of law. Even the entire industry were put into great surprise as to where to engage, how to engage and where to engage. This is a big question because of various decisions of various Supreme Court pumping in, and the unions took a lot of advantage in the entire thing. Even though the very object of enactment is to regulate and where necessary to facilitate abolition system, some of the decisions exceed the object of the legislation. You see here in case of the various decisions Supreme Court, if it is really analyzed, the courts took a very socialistic view to provide this kind of a relief to contract labor. Actually, the Contract Labor Act, if you go through, there is no provision about all these things. The court took an extended socialist in the sense that, okay, they took a humanitarian consideration on this issue and then gave a very liberal meaning of the entire thing. Now, this is the position prevailed up to our new era. Now, broadly we can classify the era into two areas. There is pre-LPG era, that is prior to 1991 where we were in a controlled economy state, and then after 1991 where we are in a globalized state, that is LPG era, there is liberalization, privatization, globalization era. This is another view. Now, all these judgments mostly it fell in the first part of the area, that is pre-LPG era before 1991 came into picture. Now, after 1991 the whole industrial scenario took a different view, as you know. The requirement of contract labor became very high because on account of the global competition of the products and services across, the entrepreneurs had to reduce their cost of manufacture and increase the employment potential in the country also. On account of this, what happened? There was no, it became very difficult because the adjustment of manpower was a big problem. The Industrial Disputes Act did not provide the management to adopt new technologies without the consent of the union. They cannot increase the production without the consent of the union because Section 90 of the Industrial Disputes Act comes in the picture. And all these things came in a block way for all the employers. So the only alternative was that they had to think of increasing the outsourced people, and they thought of increase the contract labor engagement come what may. This is the kind of thing, because the employers were driven to this stage. On account of this, what happened was that there was huge employment of contract labor everywhere in all the areas. Even the state and central government were not out of this. Even for instance now, even today we find that even central government is outsourcing a lot of its own main activities to contractors. For instance, processing of passport is given outsourced. The process of income tax returns is being outsourced. In fact, in railways, all the activities other than the loco drivers and maintenance, everything is given to subcontract for cleaning and maintenance of railway coaches. In transport, again the cleaning and maintenance of buses is being outsourced. And even the P&T, or you take any area of government segment, they also went in for huge engagement of contract labor in large volumes. Now what happened? On account of all these things, the new concept also started, in the sense that temp staffing is catching up very fast. A lot of new establishments have come. They started giving temp staff to various companies, and this led to job creation because of all these factors. Because after 1991, the number of industries grew enormously, peaked at a high level, providing a lot of employment opportunities to various people. In this scenario, what is the judicial pronouncement and views? Let us examine it. Because is there any shift in the thinking of the judiciary on account of this post-LPG era? What is the scenario? Let us have a look. Of course, there is drastic improvement. I will show you one by one. After 1991 till date, what is the situation? Now here the same Supreme Court which said earlier has reversed its decision now. It says that if there is no registration and no license, this will not result in regulation of the contract work, but it will only prosecution under section 23 and 24 of the Contract Labour Act. Earlier the same Supreme Court had held that if there is no registration, no license, the contract labour shall be deemed to be employees of the principal employer. But the same Supreme Court now has reversed the view, because very simple fact that the Act doesn't provide a mandatory direction to provide employment in case of no license and no registration. Okay, penalize them. That's all what it says. Then the entire thing. Now, on account of this decision of Dhananath's case in Supreme Court, lot of other courts started following the same view. Failure to obtain registration license by principal employer and a contractor respectively would not make the contract system a sham and a conflict one. This is Jharkhand High Court in 2014, last year. Then again, same case, the Supreme Court reversed their own judgment. At that time, they said abolition of contract system will not result in employment by principal employer. Also, mere violation of contract labour will not result into automatic absorption of contract workers. Now, the whole trend is reversed now. In case of Madras High Court decision, when the principal appointed, when the employees are the employees of the contractor, then the principal employer is not at all liable for any kind of this one, because the contract labour are employed by the contractor, not by the principal employer, and there is no question of any relief. Now, Allahabad the High Court has said the same thing, contract will get relief only when the contract is sham, otherwise no. Then Madras High Court has said the contract labour system is illegal when it is sham, otherwise no. Then Calcutta High Court has said that reinstatement contract labour without finding of the contract of sham is to be set aside. If the contract is not genuine or conflict, the contract will be treated as employees of principal employer. In this case, what happened was that there was a prohibition under section 10 to engage, provision of engagement of contract labor. Still, the company continued to engage contract labor, hence the Bombay High Court has said, no, this is not correct. Now here the main concept has come out now. There are four various Supreme Court decisions in the case of Devganga Chemical Works, Silver Jubilee Tailoring House, then Shivanand Sharma vs. Punjab National Bank. The Supreme Court has come with a new theory to support this. They said the test of supervision and control should be the prima facie case test for determining the relationship of employment. Here what they say is that what is the extent of employer-employee relationship between the contract labor and the contractor? What is the relationship between the contract labor and the principal employer? These are the tests to be applied before taking any decision. They said that if the contractor is directly supervising and managing his own force, he is an independent person, principal employer has no say in this, he is no liability. But supposing now the reverse happens in the sense that the contract labor is supplied by the contractor, but the entire supervision and control is done by the principal employer, then you don't have a good case. So the Supreme Court very clearly, please understand this and then shift the responsibility to supervise and control the contract labor on the contractor but not on you. Then this new principle which have been evolved and lot of decisions are being taken. Now Jharkhand High Court has said very clearly, payment of wages, control and supervision are decisive matters to determine whether the contractor or employees employ the contract labor. Who is the employer? So these are the primary questions to be asked. This new shift has taken place in the judiciary on account of all these things. Then workers of contract labor cannot be thrusted on the principal employer in the absence of control and supervision. Same Supreme Court in 2011 has held. Look at this. Then again Guwahati High Court has done the same thing. Contract labor cannot seek regulation of absence in absence of notification of absence, notification of abolition. Supervision of contract employees will not create relationship with the company. When the contract employees were supervised with principal employer, then the contract will be sham, bogus and camouflage. So here the court says that you have to shift the responsibility of supervision and control on the contractor, not on the principal employer. One thing we have to be very cautious, that is, as per Rule 25, the contract employees performing work of regular employees will be entitled to the same rate of wages and holidays. Madras High Court in 2012. So you have to be very cautious as far as this is concerned. You have to ensure that the same wages is given for the same type of job, whether he is the contract worker or regular worker. So if we can summarize the judicial pronouncements now, the pro-LPG era from 1991 till date, we can summarize it like this. There is no automatic absorption even in case of abolition of system. Contract workers cannot claim absorption. Contract workers cannot raise a dispute unless the contract is a sham contract. No license, no registration, no license. Contract workers shall not be deemed to be the employees of the principal employer. And important thing is that principle of contract of service and contract for service. This is another new principle which has been evolved by the court. I will just tell you that. So what happens now, there is a perceptible change in the judicial pronouncement in this area. The courts have strictly adhered to the interpretation of law. Now, because earlier they were not adhering to the interpretation of law, they were going by the virtue of what you call, took a very socialistic view of the entire situation. But now it's a question of strict interpretation of provision of the Contract Labour Act, where it doesn't provide anything about regulation or absorption or anything like that. So actually there are innumerable number of judgments nowadays. This is coming upon every month. We are coming across a new decision on this matter. Now the things have changed quite a bit. Now the thing is that we need to draw some various hints and laying down certain principles so that the engagement of contract labor can be within the parameters of law. This we need to draw a clear-cut thing. Now let us examine the point is normally put forth by the union for for the contract labor before the courts. Normally, they say non-compliance of legal provisions on the part of the principal employer. This is one of the normal complaints filed by the union to the authorities. Workers are engaged in perennial nature of work. The contractor is only mere supplier of workers. The contractor workers are under the supervision and control of this principal employer. There exists employer relationship between the principal employer and the workers and the contract workers. Finally, the contract is sham and camouflage. So these are the questions normally posed by the union for contract labor before the courts. Hence, we need to counter each argument that may be put forth by the union, fully utilizing the hints, suggestive guidelines and principle enunciated in various judgments of the court. Now, just to say what do you mean by a sham contract? Now, it has been out of the judicial interpretations account. Engagement of contract labor when there is prohibition by the state or central government, it is a sham. The contract will be utilized for any other work other than for which the license has been granted. I gave the example already on this. The non-compliance of applicable legislation by both by principal employer and contractor. The courts will never accept this kind of a situation. Then it should be contract of service and not contract for service. First hit by the judiciary. Then let's see, the contract must be for contract for service and not of contract of service. This must be executed and demonstrated. Let me explain to you what do we mean by these concept of contract of service and contract for service. Look at this table. On the right side of the table you will find contract of service. On the left side you find contract for service. In the contract of service, number one, it is purely supply of labor. The end product or service is not specified. The contractor shall be directed that I want 100 people today, you please supply me 100. The end product of service is not specified. For which purpose the people are being taken, the contract is not aware of it and is not worried about it. And there is control and supervision of such people by the principal employer, because it's only supply of labor. Who is supposed to manage and control? It's only principal employer. Then bound to obey the orders and instructions of the principal employer. There is no discretionary powers for the contractor or even for the contract labor. Right to reject the product or services or refuse to give work is not there. Then the most important thing is the invoice by the contractor is based on the number of persons supplied by him. It is not on the service. So this constitutes what is called contract of service. Contract for service is a different thing. It is like this. The end product of service is specified. Take for instance now, if it is specified saying that my area of my enterprise is 10,000 square meters. Now you are supposed to look after the housekeeping of 10,000 square meters, that's your job. It means that you are quantifying the end product of the service. Like that it should be defined. And no mention of supply of labor. You should never mention the supply of labor. I want this job to be done by you, that's why I am giving the contract to you. Please do this service and give back to me. That's all. How many people you employ, that's up to you, depending on the work. But the service is quantified. And they are bound by instructions of the contractor. The entire supervision and control of the contract labor is done by the contractor himself, not by the principal employer at any circumstances. The contractor has discretionary powers. He can use the discretion. Today workload is more, I can take more people. Workload is less, I got less. So he can all use the discretion. The contractor is responsible for deficiency in service. Now he will be questioned as to why this is not done, that is not done. The contractor is expected to explain to the principal employer. The invoice is again important by the contractor is based on the quantum of work or the service, is depending on that. So it never speaks of the manpower. So this is the difference between contract of service and contract for service. What Supreme Court says is that if you engage people for contract of service, it means that there exists the employer-employer relationship between the principal employer and the contract workers directly, and your case is bad, the contract is sham. Whereas if you engage on the basis of contract for service, the relationship is between the contract workers and the contractor. You are not in the picture, principal employer is not in the picture. Hence, this contract is a legally framed contract, it holds good. So here, in contractor, as I told you already, there is greater amount of supervision and control by principal employer. I explained to you. In contractor service, there is no supervision and control by the principal employer. The test is to judge the employer relationship between these three people. The Supreme Court, one of his judgment, it has said that the greater the amount of bilateral control and supervision, the stronger would be the logic for holding it to be a contract of service. Look at the caption by the Supreme Court, so beautifully have been worded. Now, what is strategy to be adopted? The strategy is very clear, based on the guidelines of the Supreme Court, that the contract must be specified and quantified service or even product. The contractor alone must exercise control and supervision. No direct handling of labor by principal employer. The contractor must demonstrate by engaging his own supervisors. Right through recruitment to exist, all aspects of engagement are handled by the contractor. This is strategy. Supervision in terms of production, discipline, engagement is essential, and there must be minimum control by the principal employer. In fact, in Jharkhand High Court, in one of the recent judgment has said, minimum control will not lead to a damaging relationship between principal employer relationship. It's okay. But predominantly, the control should be exercised by the contractor and not by the principal employer. The second hint by the judiciary, what they say, ensure legal compliance by both contractor and principal employer. I don't think it's difficult. There should not be any non-compliance which becomes a point. The next third hint by judiciary, do not engage or continue to engage contract labor on jobs which are prohibited by central or state government. Be very clear. I don't think there's difficulty in adhering to this. We should not do this. The fourth hint by the judiciary, do not engage contract workers other than jobs for which the registration license have been taken. Now, we have listed out some do's for the principal employer in line of these various decisions of these various courts. Now, here do ensure that the contractor has the establishment of his own, that is proprietorship, partnership, private limited, especially in the area of and requisite expertise. Ensure to collect all copies pertaining to his firm. It can be PAN, it can be service tax registration, partnership deed, articles of association as the case may be, list of directors, list of partners, proprietors with address, etc. Ensure that he has obtained ESI and PF code on his own, because recently there are many cases which has come in this direction. When I was in the Provident Fund, if the contractor has got independent code number of his own and he is considered as a separate entity and the principal employer is not responsible for the default on the part of the contractor in payment of Provident Fund dues. A very, very landmarking judgment has come. From this point of view, we have to ensure that the contractor has his own independent establishment with all these parameters. It is very important. Then review the agreement legally and a judicial stamp paper. Spell out very clearly the nature of work to be entrusted. The nature of work mentioned in the agreement must be same as mentioned in the certificate of registration and in the license of the contractor. There should not be any variance. All three things, identical things should be same. And the certificate of registration and license by the contractor is valid at all times. Then attendance recording system should be separate and exclusive for contractors. The contractor issues ID cards of his own and the name of the company should never appear on the ID cards. The contractor supplies uniform which is different than that of the regular employees of the company. The company logo and emblem should never appear either on the ID card or on the uniform. No group photos are taken with the regular employees or executives of the company. In the matter of discipline, appreciation, whatever it is, no letters or memos, appreciation letters, etc. are to be issued by the company. Everything should be issued by the contractor, not by the principal employer. And no payment be made to any contract worker directly by the company. Documents in shop floor do not mention the names of the contract labor. Then carry out the examination appointment letters issued by the contractor. you have to ensure that the name of the company not to appear that he shall or he will carry out the work instructed by the contractor in that establishment. So we have to take care of all these things. The company not to involve directly in recruitment processes, performance evaluation. These functions can be handled by a consultant whose charges may be paid by the contractor. The contract workers to be covered in PF and ESI at all time and check remittances every month. Contract workers do not attend any review meetings, only contractor must attend all these things. And carry out a periodical vendor audit to ensure there are no non-compliances. Contract workers not engaged in any other line where license is being granted. Do take undertaking from each contractor every month that the contractor has paid the wages on time, remittances of PF and ESI and compliances under the legislations applicable to him. And the most important thing I would like to stress upon is that the morale and motivation. Notwithstanding monetary compensation, there is need to ensure morale of contract workers and the motivation is kept as much high as possible. Here, for instance, now we know that the contract level certain month, they are being paid the minimum wages as applicable or little more than that. Definitely it is lesser when compared to the regular workers in an organization, definitely, obviously. So what is the motivation force for them to keep this one? As far as productivity is concerned, it is a known fact that the contract workers give more efficient and more productive than the regular workers. So we need to keep up the morale and motivation of the contract workers in spite of the fact that they get less salary because this is a major issue. If you don't take care of the morale and motivation of the contract laborers, it can explode at any point of time because after all the contract laborers are also human beings. Some programs of motivation like for instance technical upgradation training so that there is personal value addition to them to enhance their employability in the market, and soft skills programs, then other engagement programs, social engagement programs. But these programs must be organized by the contractor, and even the principal also doesn't matter, they can organize this. Now if you do all these things, at least we will be doing some justice. But now, luckily what happened is that things have changed now. The judicial pronouncements are little in favor of engaging contract labor, provided we follow all these guidelines, Supreme Court meticulously. Then we can definitely move forward. Thank you.